Judge, there is a preliminary matter on this involving Miss Leslie Cole, who is the attorney for Ashley Blair. We had issued subpoenas for the minor children that had made the disclosures that are the meat and substance of the petition that we filed. So I think we've got to hear that motion before we move forward with anything else.
All right. Good morning.
Cannon County Bar. I represent Miss Ashley Blair for the...
So that we're clear, the children that are being subpoenaed are not the children of Mr. and Miss Duffy together. They are Mr. Duffy's children by a prior relationship?
Yes.
Is that correct?
If you'll remember, Your Honor, you had our minor children,
You're fine.
our minor children attend visitation when those children were in Mr. Duffy's home for safety purposes. And now that they've made some disclosures, the children in this case are too young to come to court. So we ask that the older children come to testify as to the disclosures they made in the other case and in this case.
All right.
So this is my motion to quash those subpoenas for the older children. The children Ella, Parker, and Jackson. Ella is 12. Jackson and Parker are twins. They're 10. The motion is on two separate grounds, a procedural ground and then a substantive ground. The procedural ground is that the subpoenas are incorrect. The subpoenas that were served, they summon the children first to Miss Duke's office rather than to court, which is the 210 East College Street. The date listed is also 5/26. We were informed by email that the date had changed to yesterday, June 15th, and my office was not informed until June 3rd that today was actually the correct date. We have not been provided with a copy of any order showing that the subpoenas were continued or that today is actually the correct date that the subpoenas were continued to. So that's the procedural ground. On the substantive ground, these children are 10 and 12 years old, testifying against their own father, who they are exercising parenting time with. Mr. Duffy is still having significant parenting time with these children. The case that was filed in Wilson County was dismissed after a probable cause hearing, and he has significant unsupervised time with the older children. It would open them up to undue psychological and emotional harm for them to testify against their own father, who they're still seeing regularly, in a case that doesn't relate to them. That's just not fair to these children when it doesn't relate to them specifically. They haven't testified in any of their own cases relating to them directly. They did not appear in either the divorce case or the Wilson County dependency and neglect. They spoke to a guardian ad litem. We would ask that these subpoenas be quashed to protect the children and on the procedural grounds. If Your Honor believes that their information is absolutely required, we would ask that the least harmful method be used here and allow the children to speak to the guardian ad litem in this case so that they are not exposed further to the court process. Thank you.
Judge, respectfully, when the case was continued on the 26th, and it was due actually, I believe, to the mother's availability to have the children here, the order would have reflected, and it's just not been entered yet, the order would have reflected that the subpoenas remain in place. And everybody's here to testify. Your Honor, unlike the court in Wilson County, has an extended view of what has happened in this case all along. So Your Honor is well aware of the propensities of the father for erratic behavior, suicidal ideations, all of the things that the court has warned him against doing with these minor children. And Your Honor, I think, is probably much more aware than that Wilson County judge is of the dangers to these minor children. Your Honor has said it several times. This is the case where Your Honor witnessed him, and it just so happened we have had a video from the arcade at the bowling alley.
I remember the case.
Yeah. So these minor children made disclosures to their mother that were so significant, she reached out to Miss Duffy. But for the mother, Ashley Blair, we wouldn't have known any of this was going on. And now all of a sudden that something doesn't work out for her in Wilson County, she doesn't want to try to protect my client's children who are younger and cannot speak for themselves. I agree with Ms. Cole that the least harmful method for these children to testify and to bring these allegations to light is absolutely appropriate. I'm not looking to hurt minor children. I don't love the idea of them having to testify. But in this case, it's absolutely necessary. Otherwise, this man continues to hurt the minor children, telling them he's going to kill himself, carrying a gun around, continuing to drive a limo in the middle of the night with the minor children, leaving the minor children home alone by themselves. Big issues for the court.
Ms. Morris?
I represent Mr. Duffy in this action. As you know, our position is really to ask the court to dismiss this matter because most of the allegations that are before the court are based on these issues that have happened with Mr. Duffy and the older children. Meanwhile, the case in Wilson County has found no probable cause and has dismissed any action there. He's, again, as the attorney for Ms. Blair stated, he's having regular unsupervised visitation with those children. Those parties are very close to reaching a permanent parenting plan settlement in that case, as well as establishing some kind of family therapy, which we agree would be appropriate. As this court has heard before, a lot of the issues that have happened with Mr. Duffy in the past do relate to some behavioral issues with Parker and his ability to manage that. And we admit that there have been issues with Mr. Duffy being able to manage Parker, and that is the bulk of what's going on here, the bulk of the incident that stemmed to all of these allegations. And he and Mr. Duffy and Ms. Blair, who's Parker's mom, are really trying to work through those things. Again, the Wilson County Court has found no basis to suspend Mr. Duffy's parenting time of the older children. This case is really tailing onto that. And so our position is at this point, this case should be dismissed since it is entirely based on those issues in that Wilson County case. However, if the court does not dismiss it, I would also ask that the children be able to, rather than testify in court, speak through the guardian ad litem, Ms. Furlong-Smith, and that she also be able to interview everyone else in this case. As the court probably recalls, she's already done home study visits of my client's home. There's been an expert evaluation. So we were really doing very well in this case. And again, this is an issue that I think is really tangential.
Ms. Furlong-Smith, do you have anything you want to say?
I would be glad to talk with the children, the other children. I haven't. Of course, I'm not involved in the case, but I'd be glad to. I hate to just dismiss this outright until we get more.
Well, let me say this. We ain't in Wilson County. So the fact of the matter is, if in fact the Wilson County has been dismissed by juvenile court, it may be a different standard entirely than what is relevant as far as the evidence that this court will consider. But I will also say that the law is set up to try to protect young children, especially children who have been abused or have been subject to abuse, from having to come into court and testify if at all possible. That's why we have an exception to the hearsay rule, that statements of children regarding abuse is an exception to the hearsay rule. So the children don't necessarily have to testify, but the statements they made could be brought in through another witness. Secondly, in criminal cases where individuals, where children are subject to sexual abuse or other abuse, the law is set up to allow them to be interviewed by the Child Advocacy Center, and a video of that interview is substituted for them having to actually go through the details of the case. So there's quite a few protections in the law intended to try to protect young children from having to come in and face having to testify. Understand, it is not particularly pleasant if anyone has ever had to testify sitting in the witness stand and being questioned and cross-examined is not a pleasant thing for anyone. And I fully understand that. So I'm quashing the subpoena, and I am ordering that instead that Ms. Furlong Smith is going to be allowed to speak with the children. And I am putting an order down here that Mr. Duffy and anyone else is prohibited from trying to influence these older children in any way or trying to give them a statement to make to the guardian ad litem. I want them to be unrehearsed. I want them to have a free and opportunity to speak with the children without any sort of threat of harm or having ramifications. In the interim period, obviously, I am not dismissing this action because, as I stated, I think there's a different standard for what was brought in Wilson County for what we're dealing with. And in the interim period, I don't know how long it's going to take you to do that, get that information made. My job is the best interest of the children. My only goal is to try to protect children and to make sure that they have a good relationship with both parents. I have a long history with this case, and we have gone round and round with it. And there have been some concerning issues with Mr. Duffy. I've heard multiple testimony I've heard testimony in the past where there was a physical abuse of the child, one of the children at the bowling alley. That was explained with more or less being angry by Mr. Duffy because the younger child had walked away from the older child and he was responsible for it. There was an instance where Mr. Duffy was working his job, driving late at night on an Uber or whatever it was that he was doing, and he had taken the children with him with a pistol to go help somebody recover some phone that had been left in a car. There are just a lot of concerning things that have happened in this case that they make me feel that it is important for the evidence that these older children may have can be brought in through the least harmful way to them possible. So I'm simply going to order that take place. I just need to know kind of how long we're talking about Ms. Smith, because clearly this is a case that needs to be heard with some urgency so that if it's determined that there is no basis for those older children's statements, then this temporary restraining order needs to be vacated. If they substantiate it, then obviously we need to have a hearing to determine that.
Judge, would it be possible, since they're juvenile court records, we are not entitled to get those, would it be possible to make sure that the mother of those minor children produce the...
Well, she's not a party to this action, and she, other than coming in on a motion to quash the subpoena, I don't think I can order the mother of the older children, who is a non-party, to subpoena those records or to bring them in. You can request a judicial subpoena and see whether or not the juvenile court would honor that.
Is it, I'm not interested in necessarily having them. I wanted Ms. Smith to have access to them for purposes of questioning the minor children, because those statements were made under oath. So I don't know what purview this court would have to issue an order for her to be able to get those.
The only way of doing it would be to issue a subpoena to the juvenile court for those records to be brought to this court, and then I can put an order down today that Ms. Smith would have access to those records under seal. She would make an in-camera review of them. And again, my question is, if this order prevents Mr. Duffy from having contact with the children in this case, then there is an urgency to getting this resolved so that if it is found to be unsubstantiated, that we can allow Mr. Duffy to resume his contact with the minor children. And
I'll make myself available. And Ms. Morris has said she will get Ms. Smith a copy of that petition just so she has it.
Whatever I can obtain from the Wilson County Court, I will file and, or provide Ms. Smith.
I'm looking at the 22nd of July as being the next time that I could. That's not a date that I had normally given out for Chancery here. Ms. Morris. Ms. Smith.
Would the court want
Well, if you're going to, here's the issue. Once you find out what these children say, then you've got to determine how you're going to introduce that testimony of what those statements. And guardian ad litem's report, in my opinion, could not be substituted for a live witness who would testify that the children made. If it's traveling under an exception to the hearsay rule, you got to have a witness who's going to testify what the children said. So either Ms. Smith may have to testify in person if you're wanting to introduce it that way. And when are we thinking that you'll be able to talk with them, Ms. Smith? Okay. Let me take a recess. I'm going to check on my calendar to see the month of July. I'm supposed to be in Cheatham County, but there are a couple of days when I've got on my calendar to be back here. And I want to see if there's other. Wednesday is your day to be in juvenile court. All right. We'll take a short recess.
All rise. Court is now in recess.
That is that we're going to put an order down that allows Ms. Smith to communicate with the minor children that Mr. Duffy has with his other ex in this case, that she will be able to talk to them, and that can be arranged in any kind of communication she has with Ms. Morris. May be able to get those records for her, at least a copy of the petition that was filed in juvenile court, so that Ms. Smith can see what the allegations were. And it's my understanding she's going to try to do that on the 27th. And beyond that, we're going to set a review on the 21st day of July at 1 o'clock here in this courtroom to one way or the other resolve this case or have a hearing on the issues. My understanding is the parties will continue to communicate regarding a resolution. So, thank you, Judge. All right, thank you. And then obviously I have quashed the subpoena, so.
I'll prepare an order.
But it does need to reflect that the quashing of the subpoena does not in any way, was not in any way intended to inhibit Ms. Smith from being able to speak with the children. I'm doing that instead of actually subpoenaing. All right, thank you.